Delhi Chief Minister and Aam Aadmi Party Chief Arvind Kejriwal has been granted interim bail by the Supreme Court, but he will continue to remain in custody. In this video, we look at why Kejriwal will remain in jail and ED's powers and the possible checks and balances on it.
So the Supreme Court on Friday, that is the 12th of July, granted Arvind Kejriwal interim bail in the excise policy scam where he was arrested by the Enforcement Directorate. This is separate from the regular bail that a trial court had granted him last month, and that has been stayed by the Delhi High Court. This is separate from that. This is a plea where Kejriwal had challenged the legality of his arrest, basically saying that the Enforcement Directorate need not have arrested him at all. So now the Supreme Court has essentially cast a shadow on the Enforcement Directorate's need to arrest. The timing of the arrest, like it was talked about that he was arrested just before the Lok Sabha elections. So the Supreme Court's verdict today casts a shadow on that entire exercise. But despite this, Kejriwal will continue to remain in jail for now because he is still arrested by the CBI and continues to be in the custody of the Central Bureau of Investigation. So that bail hearing is likely to come up sometime this month, possibly on the 17th of July, and a trial court has to again grant him bail in that case. However, the threshold for granting bail in a CBI case is far lower than it is in the ED case. The Enforcement Directorate, which is governed by the Prevention of Money Laundering Act, has a really high threshold for the grant of bail. So conversely, the argument that Kejriwal made was, if there is such a high threshold for granting bail, then there must also be a very high threshold for the ED to arrest a person. So the ED's power to arrest essentially comes from Section 19 of the Prevention of Money Laundering Act. This is the stringent special law that governs all offences related to money laundering. And there is a particular phrasing in Section 19 which says that the ED director or any officer in the same rank who has been designated by the government can, on the basis of material in his possession, which means whatever material during the course of investigation that has been collected by the ED, if they have reason to believe, these words are very important because it says reason to believe that any person has been guilty of an offence punishable under the Act, which basically means that if the ED director, based on the material before him, feels that there are reasons to believe that Arvind Kejriwal is guilty, then he could be arrested. What Kejriwal's lawyers challenged is that these words, reasons to believe and material in possession, these are not just vague words which have a very wide ambit, but they have to be contained and given the standard of due process in law. Reasons to believe cannot be subjective, cannot be the whims of the ED, but it has to be put in writing and it has to be something rooted in what is before the Enforcement Directorate. And even, for example, the phrase which says material in possession, right? Here the court says that material in possession doesn't mean just about anything, because this material has to show that the accused is guilty, right? And for establishing guilt, you need a certain standard of proof. So that material must be almost like admissible evidence. It can't just be stray statements or, like in Kejriwal's case, approver statements. It has to be admissible evidence, which means a certain higher standard of proof. Now, if all of this sounds technical, it is because the case is technical on this aspect. And these technical grounds really become important because the law is very stringent. Under the PMLA, getting bail is virtually impossible because the standard is that an accused will have to prove that he's not guilty of an offence in order to get bail, right? So that standard of proof is almost like a mini trial. So getting bail under PMLA in an ED case is virtually impossible. So it is then that these checks and balances, each word being defined to its core meaning, that all of these things become really important in interpreting the law. So the court, of course, has said that while all of this is there, that the ED has to be held to a higher standard of proof, these issues need consideration by a larger bench. So this case has now been referred to a larger bench. So the court doesn't really express any merits on Kejriwal's case himself. The court is not saying that his arrest is legal or illegal, but the court is saying that since we have a doubt about how ED can use its powers, for the time being, Kejriwal should be released on interim bail. In fact, the bench uses the words, he's been incarcerated for over 90 days, which means he should be set out till a final decision is made in this case. While reading out the order, the court also said that, it is not for the Constitutional Court or the Supreme Court to have an opinion on whether Kejriwal should continue as a chief minister or not. But like the Aam Aadmi Party and Arvind Kejriwal himself have said so far, that he will continue to be the chief minister of Delhi. And now that the court has granted him interim bail, and as and when he comes out, he should continue to be the chief minister of Delhi.